I think developing a protocol, or what I call an IP policy, is very important. It's simply just to focus on the issues that you want the policy or the protocol to address. Yeah, one of it is the scope of it. Who is it covering? Is it your employees, the people you work around, the people you deal with, people you get IP from? You also have to put in the issue of the governing laws, whether it's copyright laws, patents, or trademarks, or whatever laws that are governing that policy and protocol. You have to put in the rights and ownership of rights, yeah? Whatever you're dealing with that is covered by IP, who owns them, and when are they used, when is consent needed, when is it not needed. So the question of ownership of rights is very important to put in such a policy or a protocol. I think the question of ownership is already dealt with in the Traditional Knowledge and Traditional Cultural Expressions Act. It actually defines who an owner is. It could be a community or an individual, because we have knowledge that is owned by individuals, especially with knowledge that is like medicinal ways of treating things. You will find sometimes those are owned by individuals who pass it on from generation to generation. But then you have also community-owned knowledge. So we have to go back to the Act to see who is an owner, and then you define ownership in that context, yeah? So the Act recognizes you can have an individual owner, but you can also have a community owner. You can have an organization that owns the traditional knowledge. And so the question of ownership, you'd have to go back to the law, what it provides, and define your owner in that context. Now, once you have identified your owner, then you also need to know, how do I acquire what I need to acquire? The Act also is very clear on the issue of exploitation. When you're talking about exploitation, what do we mean? Generally, if you do things like exporting that knowledge, manufacturing, importing, I mean, you go on a big scale for selfish purposes where you are benefiting as an individual, then that's exploitation. Then that one you need the consent of the individual owner or the community, yeah? And so I think the law is very sufficient on the issue of ownership and the issue of exploitation. What are you using it for? How do you want to use it for? How is it benefiting the community? And then, of course, it comes down again to benefit sharing. Once something is come out of that economically, how does the community benefit from it? One of the ways in which communities could benefit is probably building art centers, building something, maybe a library, a community library, something that the community can benefit from. Because if you receive money from such exploitation, you're not going to distribute it to individuals in a community. It's not going to help, yeah? So you can create ways in which the community at large can benefit from that money that comes in. Okay, so protection of indigenous knowledge actually is just the documentation of it and preventing others from exploiting it, and especially like multinationals, like foreigners, when they come and they pick fabric, they come and they pick something, ideas, and they go to exploit it. So that's the protection, yeah? And the protection is usually for the community or the individual who has that knowledge. But the Traditional Knowledge Act and Traditional Cultural Expressions provides for documentation and preservation. So that is how you can protect. There are other ways you could protect traditional knowledge if they could fit in those forms of IP, like patents, like trademarks, like copyright, depending on whether they can fit in that form of IP for protection, yeah? The issue of sharing across communities, that is allowed. You may even find two communities that actually share the same traditional knowledge and traditional cultural expressions. So what the Act has provided is that the different county governments are going to document within their counties the knowledge and the cultural expressions that are there, regardless of whether they are shared or not shared. The question of sharing is not a problem. The problem is benefit sharing, when something comes out of it in terms of money. So that is what people need to agree upon. When something comes out of this in terms of money, how does the community benefit? But sharing across communities, there's no problem. If they can fit in the definition of exploitation, that's the problem. When you want to exploit, when you want to export this, when you want to turn it into a manufacturing venture, then that becomes an issue of getting consent from the owner or the community of that traditional knowledge. I think for me, creatives need to change their way of thinking about intellectual property. And the moment we begin to look at intellectual property, the way you look at your land, the way you look at your car, the way you look at your house as property and protect it, yeah, then that will change the conversation. So far, a lot of people have had intellectual property created for fun, for other purposes, but for economic exploitation. Yet in developed nations, people exploit their IP economically and they gain a lot from it and they can live from it. But in Africa is where you find very talented creatives who are very poor. So I think for me the conversation is to start at changing how we look at intellectual property. Once you look at it as tangible property that can make money for you, you can live out of it, then that will change the conversation. Awareness creation can never be finished. It is a constant and consistent issues, and all the players must be involved. The NGOs, the government, the private sector, the rights holders themselves, everybody must be involved in disseminating information around intellectual property. Then we can reach more and more people when we do that. Right now in Kenya, the specific laws is the Copyright Act, and then you have the copyright regulations. It just provides for protection of your creations for literary, artistic, and musical works. When it comes to traditional knowledge, traditional cultural expressions, we also have the Traditional Knowledge and Cultural Expressions Act 2016. Again, it provides for documentation and preservation of traditional knowledge and cultural expressions. It is yet to be fully implemented because the regulations are yet to be out, but that is the act that we're using. Kenya is also a signatory to many treaties and conventions around copyright and traditional knowledge and cultural expressions. But the good thing is that usually once you sign or ratify a treaty, then you domesticate it into your law, so then that means that your law is sufficient when it comes to guidelines around copyright and copyright law. I think this is one of the sessions I've enjoyed doing a lot because I do a lot of training with different groups, and so it was one very interactive group, and we had a lot to take in, but also the interactive sessions of asking the questions and, you know, just engaging and giving live examples, live experiences for them. That for me was really good. I think there's still a lot of work to be done in this area because intellectual property is very technical and it's not something that is easily understandable in a one sitting. So I look forward to more engagement, not just with the African digital heritage, but even with the various players in the room, like the county governments. As I said earlier, the TK Act has given mandate to the county governments, but also to the national government through the Copyright Board. So that means that collaboration will have to be there. So I'm really excited to have done this, and with this group. It was a very diverse and rich group, and very responsive and interactive to the session.